Ladies and gentlemen, good evening. I'm Harvey Shapiro, and I'd like to welcome you to one of the monthly debates sponsored by the Smith Family Foundation. Tonight, we're going to be discussing the Kelo case and its consequences. As some of you may be aware, a couple of years ago, Susan Kelo and several other homeowners in a neighborhood in New London, Connecticut, filed a lawsuit after city officials announced plans to take their homes, tear them down, and make way for a riverfront hotel and a health club and some office space. The residents sued, arguing this was an unjustified taking of their property. The case wound its way up to the Supreme Court, where essentially the Supreme Court held in a 5-4 decision that it was appropriate and legal for the city of New London to take their property. This has been a kind of the most recent or the most interesting example of many debates over the right of eminent domain. This is the idea that the state can take property for public purposes, but there's a great deal of discussion and debate about just what constitutes a public purpose. It's clear that if you're in the one and only path for a bridge or a road or a development of some sort along those lines, that most people would agree it's appropriate to, unfortunately, give up your home or give up your property so that this particular infrastructure element can be constructed. But from there, moving along the spectrum, it becomes more cloudy, more debatable, I think. What is a public purpose? Beyond that sort of thing, does it involve, for example, developments that will spur economic development? Just, for example, building, say, a basketball arena in Brooklyn or a football field on the west side of Manhattan, just to take two hypothetical examples. Are these reasonable public purposes? And what about simply taking your house and turning it over to a business on the grounds that it will spur economic development in a declining neighborhood, in an impoverished neighborhood, and it is not an unreasonable argument to say that putting up a store, putting up a movie theater or a McDonald's will, in fact, improve the economic health of a neighborhood ultimately. But is this a good reason to take your property? And what about simply replacing your house with a more expensive house that will generate more tax revenues? Is that a reasonable response or not? This is a controversial area, one that has had, I think, interesting implications as a result of the Supreme Court's decision. There's been a number of political ramifications. Several dozen states have been discussing legislation that would clarify and limit just what kinds of public purposes fall under the notion of eminent domain. We want to explore tonight the implications and ramifications of the Kelo case and more generally the issue of eminent domain. And we're pleased to be joined in sponsoring this event by the Federalist Society's New York Lawyers Chapter. We have with us two lawyers who are going to share their views not only on the legal issues, but I think on the broader political issues as well. We'll be hearing, first of all, from Scott Bullock, who joined the Institute for Justice at its founding in 1991 and serves as a senior attorney there. He's been active in a number of property rights and eminent domain cases, and he was the co-counsel and, in fact, argued the Kelo case in Kelo versus the City of New London. He's also been involved in a successful campaign against eminent domain in downtown Pittsburgh. He spearheaded litigation that saved the homes of a family in Canton, Mississippi, from an effort by the state to take their property to build an automobile plant. For that accomplishment, he won the top civil rights prize offered by the Mississippi chapter of the Southern Christian Leadership Conference. He's written widely on these kinds of issues, has appeared on television, and I've noted finally that Scott Bullock was born in Guantanamo Bay, Cuba. He's joined tonight by Professor Michael Dorf, who's a professor at Columbia Law School and whose teaching and research interests are in this area as well as in other constitutional questions. Professor Dorf is clerk for Supreme Court Justice Anthony M. Kennedy, as well as for the Honorable Stephen Reinhardt, a U.S. Court of Appeals judge. He's written widely on a number of topics in the law and has a new book coming out in 2 weeks called No Litmus Test, Law and Politics in the 21st Century. On some occasions, our speakers get to sell their books, but unfortunately you're here too early, and as I said, there's no futures market in this particular area. He has, as I say, written widely on the law. He has participated in a number of cases on a pro bono basis, and I think is particularly also well qualified to talk about these issues. So I'm going to ask each of them to talk for about 10 minutes. Then I'm going to offer each of them about 5 minutes of rebuttal. I will ask them some questions, and then at the appointed hour, I will ask you to come to either side of the auditorium where you see those microphones posted, and then we will take your questions as well. So let us start with Scott.
Thank you very much. It's great to be here with you tonight, and thank you to the Smith Family Foundation for sponsoring this debate. I don't have a book to plug. Maybe someday I will. And I should probably clarify that I was born in Guantanamo Bay, but my father wasn't a prisoner there. He was actually stationed there at the time, but I think he felt like he was a prisoner when he was there along with my mother and brother. The title of this talk is Should Homeowners Fear the Supreme Court's Decision in Kelo? And the answer to that, I believe, is an emphatic yes. And not only homeowners, but small business owners, churches, farmers, and other property owners throughout the country. And the reason for that is really the reason that Justice Sandra Day O'Connor provided in her dissenting opinion in the Kelo case. She said, the specter of condemnation hangs over all property. Nothing is to prevent the government from taking any Motel 6 for a Ritz-Carlton, any home for a shopping mall, any farm for a factory. Now, some people claim that, well, Justice O'Connor was overstating this, that she was engaging in hypotheticals. That is not the case. It was not the case before the Kelo decision, and it has certainly not been the case after the Kelo decision, because we have already seen the floodgates to eminent domain abuse, where eminent domain is used not for traditional public use, but for private economic development, already be open. Let me just give you two quick examples. Hours after the court decided the Kelo case, the city of Freeport, Texas, filed 2 condemnation actions against 2 family-owned seafood companies along the waterfront in Freeport to give to a developer to build an $8 million private boat marina. That's the equivalent of taking a Motel 6 for a Ritz-Carlton. Because Justice O'Connor was not just talking about that specific example. She was using that example to make the point that lower tax producing businesses, like small seafood companies, can be taken and given for higher tax producing businesses, like a private, luxurious boat marina. In July, a month after the Supreme Court's decision, the city of Sunset Hills, Missouri, approved the condemnation of 85 homes and small businesses to give to a private developer to build a $165 million private shopping mall. That's taking homes for a shopping mall, just like Justice O'Connor said would happen and in fact has happened. We did a study that looked at a mere 5-year period up to 2003 that documented over 10,000 real or threatened examples of private-to-private transfers of property throughout the country, and that was happening in 41 states. This is not a hypothetical problem. This is a very real problem, and it's happening to home and small business owners and other property owners throughout the country. I want to very quickly give you the bad news about eminent domain abuse in the Kelo case, and also what I think is some good news coming from this very bad Supreme Court decision. First of all, the bad news. The court, unfortunately, left very little, if any, protection for home and small business owners under the Fifth Amendment to the U.S. Constitution as a result of the Kelo case. Because the court said in Kelo that it was a public use if the government could show that the new owners of property would produce more tax revenue, produce more jobs, and generally improve the economic health of a community. That was a public use under the Fifth Amendment. Well, if that's the case, as the court held, then there are very few, if any, limits on government's eminent domain power. Every home would produce more tax revenue and certainly more jobs if it were a business. Every smaller business would produce more tax revenue and jobs if it were a larger business. So there really is no limit on this type of eminent domain. Now, the court did offer one limitation. Justice Stevens, in his majority opinion, said, well, the New London plan was pursuant to a carefully formulated plan, that they had a municipal development plan that was several inches thick. They had hearings, they listened to the folks, they jumped through the necessary hoops, they got the approvals from the federal, state, and local governments, and he saw that as some type of check upon eminent domain abuse. Well, all I think that really proves is that the majority opinion was disconnected from reality. I've been doing these cases for a number of years, and I can tell you in every single case in which I've litigated, there's a plan. You cannot have a development project in this country without having a plan, without going through hearings, without getting the necessary permits and approvals from various levels of government. And to think that this provides any meaningful check upon the use of eminent domain for private development, I think is entirely foolhardy and does not provide really any check upon the use of eminent domain for private development. That is the bad news about the Kelo case, that the U.S. Supreme Court essentially obliterated the public use requirement of the Fifth Amendment. But something has happened in the wake of the Kelo case that I think is very encouraging, and it's happening on a number of different levels. First of all, even Justice Stevens admitted in his majority opinion that state courts are free to interpret their own state constitutions, which also have takings clauses which prevent the use of eminent domain for private purposes, in a manner that's more protective of home and small business owners than what the U.S. Supreme Court interpreted the Fifth Amendment. So in other words, the U.S. Constitution provides a floor, but if state courts want to grant greater protections and recognize greater protections for home and small business owners under their own state constitutions, they're free to do so. As a matter of fact, Justice Stevens almost invited state Supreme Courts to do that. And the good news is that the trend in state courts is to re-examine these older precedents that essentially rubber stamp the use of eminent domain for private development and impose more limits. This is true in Michigan, it's true in Illinois, Pennsylvania, and several other state courts, and hopefully this trend will continue. A case that we're litigating right now that was just argued in January of this year in the Supreme Court of Ohio, I think will give a real indication of the direction that state Supreme Courts will take. This is the first state Supreme Court case in the wake of Kelo that will look at this issue, and the state Supreme Court has a choice to go the path that the Supreme Court took in Kelo of giving very broad authority to governments to use eminent domain for private development, or take a more narrow approach and recognize greater protections for home and small business owners. And I think that will certainly be a case to watch. The other thing that I think is very encouraging, at least from our perspective, is the overwhelming public backlash against the Kelo case. I think one would be hard-pressed to find any Supreme Court decision that has generated the type of outrage that this court case has. I think it's safe to say it is the most universally despised decision by the Supreme Court in decades, and polls consistently show this. Every poll is 90% and higher are against the Kelo case. I think the lowest one that I saw was 89%. And this is very significant on an important public policy issue where we always hear talk about this being a divided country, a 50-50 country, a blue state, red state America. That is not the case when it comes to eminent domain abuse. Not only is that true for members of the general public, it's also true for a lot of commentators and opinion leaders as well. George Will is against the opinion, and so is Molly Ivins. Tom DeLay is against the Kelo case, and so is Maxine Waters. Bill Clinton's against the Kelo case, Ralph Nader is, and so is Pat Robertson. Very rarely do you see this type of aligning of people on opposite ends of the political spectrum coming to the conclusion that this case was wrongly decided. As a matter of fact, and I think it's only a slight exaggeration to say that about the only people that are in favor of the Kelo case and the use of eminent domain for private economic development are those who stand to benefit from it: city officials, planners, and developers. You might want to throw in a couple of academics that we hear from in a little bit, and a few editorial pages as well, including the New York Times, but I think they would have to fall into that category as well, since the New York Times is building its new headquarters on land that was taken through eminent domain. The other very encouraging aspect that's come out of the Kelo case is that now we're constantly trying to update this, but 46 state legislatures have passed legislation or proposed legislation that would in some way curtail eminent domain abuse in their states. Finally, political figures, perhaps in part looking at the polls, but also recognizing the problem that, of eminent domain abuse, are waking up and are proposing legislative reforms within their own state. Now, you would think, looking at the polls, that this would be a no-brainer, that most of these legislative efforts would pass with very little difficulty. That's not the case. This is going to be a very hard-fought battle. And the reason for that is what the other side makes up, what lacks in numbers, more than makes up for in their political influence. Because state legislatures, of course, rely on city officials and mayors for political support, for getting out the vote. You know that legislative officials rely on developers and business interests for contributions. So these people know state legislatures. They know how to walk the halls there in order to get what they want. And so these battles, even though you would think would be easy, are being very hard fought. But we are hopeful that in the end, with a lot of tenacity and a lot of hard work on the part of citizens that say we will not tolerate this type of abuse of our rights, that a whole lot of good will come out of a very bad Supreme Court decision. Thank you very much.
Scott, thank you. And Michael Dorf, the way Scott describes it, you seem to be one of the few people in America who doesn't find this to be a universally despised decision.
And who doesn't have a personal financial interest in the matter. Let me begin by saying that I'm not here to defend any particular use of the power of eminent domain. I'm here to defend the Supreme Court's opinion in the Kelo case. We hear constantly from politicians across the political spectrum, but especially from the right, the importance of separating their political views from the law. What the Supreme Court did in the Kelo case was to follow the law as it has been well established since at least 50 years ago, arguably well into the earlier in the 19th century. What's happened since the decision is that people have discovered what the law is. And lo and behold, they've discovered they don't like what the law is, and they've reacted in exactly the way that they ought to when they discover they don't like the law. They've set about to change it. So that when Justice O'Connor tells you, echoed by Mr. Bullock, that you should be afraid, be very afraid, and that there is nothing to stop the government from taking your property and giving it to McDonald's or the Ritz-Carlton, that is sheer nonsense. The thing that there is to stop that is democracy. The state legislatures, the people active at the local level, are all doing the thing that we want them to do in our system of government when the Constitution is silent on a matter, namely decide it through the ordinary democratic process. The fact that the public have reacted in the way they have and that they're making headway is a sign that the Supreme Court did not need to step in and overrule either half a century or a century of precedent to get that result. Let's begin with the text of the Fifth Amendment. The relevant portion of the Fifth Amendment reads, "Nor shall private property be taken for public use." And here's the part that you rarely hear about. You didn't hear about it either in the introduction or by Mr. Bullock. Without just compensation. The government can't just take a poor person's home and give it to a rich corporation. They have to pay fair market value for it. Guess what? That is an enormous discipline on government because the just compensation requirement is enforced vigorously by the courts. People are given just compensation, and if not, they can challenge that in court, and the courts do not simply defer to some bureaucrat's definition of just compensation. They actually figure out what it is. It has another disciplining force, which is it means that local officials generally try to purchase the property they're trying to assemble on the market first, since that's easier than jumping through all of the bureaucratic hoops that are necessary to jump through in order to go ahead and use power of eminent domain. So the most important protection for property in the Takings Clause is the Just Compensation Clause. What that does is it means that this power is much less subject to abuse than other sorts of powers government has. For example, the power of zoning. Zoning is a power that local governments routinely abuse, and since they don't have to internalize the costs, they can simply stick it to property owners. Another example is regulation. Since the 1930s, for very good reasons, which I'll come to in a few moments, the Supreme Court has said that it's not going to be in the business of scrutinizing every single regulation passed by the state, local, or federal lawmakers. Why not? Well, because from roughly the 1890s until roughly the 1930s, the Supreme Court and lower courts did just that. So, for example, in the most infamous case, New York passed a law saying that if you run a bakery, you can't have your workers working more than 60 hours a week. Now, that may seem like quite enough for us today, but the Supreme Court at the time said, no, that's an undue interference with the liberty of contract of workers. Now, I know that there are people today who think that they will agree with the Supreme Court on that. The Supreme Court was right there, but the overwhelming majority of sentiment, including every single justice to have sat on the Supreme Court since the late 1930s, including all 9 of the current justices, have said unequivocally that decision was wrong. Why was it wrong? Because it substituted the judgment of the unelected judiciary for that of the local politicians, the people responsive to the people. In the late 1930s, the Supreme Court backed away from this restrictive jurisprudence. It did so because they recognized that in our system of government, the Constitution generally leaves these sorts of decisions about how to arrange our economic affairs, to elected officials, the people who are responsive to the people. It only comes in where there is a clear constitutional text or a reason to think that some oppressed minority can't defend themselves in the political process. Well, we've already seen that the argument that there's an oppressed minority that can't defend themselves in the political process doesn't apply here. Here we have an example. The 90% some odd people rising up against the Kelo decision shows that it's the majority that is going to stand against this, and there's not a serious worry that there won't be protection for property owners. In Madison's time, that was a worry. He worried about that the Constitution, we needed the Constitution to protect the rich. Today, people who are defending private property are pointing to persons of more modest means, and that's a good thing. It's a way of extending the political community for protection of property, but it shows that you needn't take this outside of the general regime of deference to political actors. The other reason why you might have the Supreme Court and other courts stepping in to interfere with decisions of the people's democratically elected representatives is if the Constitution clearly spells out that that's what you have to do. Now, Scott and others say, well, that's just what the Constitution does. After all, the Fifth Amendment says, nor shall private property be taken for public use without just compensation. And they say, well, if you can't take it for public use without just compensation, certainly you can't take it for private use. That is a perfectly reasonable inference, and in fact, the Kelo court agrees with that. Justice Stevens and Justice Kennedy in concurrence say, that's right, public use means public purpose. The question then is, how do you define public purpose? And what the majority says is, a public purpose can be facilitated through private ownership. Let me give you an example. Suppose a city decides that it wants to build a stadium, an example that we had at the very beginning, at the introduction. That is, under the generally accepted doctrine, perfectly acceptable. Now, should it matter whether the stadium is going to be owned by George Steinbrenner or the city? If it's in New York, where we have privately owned sports teams, they're going to be getting to build the stadium, maybe with some help from the city and the taxpayers, maybe not. In some other places, for example, the city of Green Bay, right? The Green Bay Packers are owned by the city. It doesn't matter one whit to the homeowner who's going to have to get out of his home and be paid for it, but doesn't want to sell even at a fair market price, whether the resulting stadium is public or private. And yet, that seems to be the key to the argument on the other side. Take a look at the New London facts themselves. From the way I understand the argument, and I've heard nothing to contradict this, had New London said, you know what, we're going to do the development ourselves. We're going to have state-run construction, we're going to have state-owned housing, state-owned malls, the state's going to own all of this. Basically, had they done it in a sort of old-style socialist system, then that would be perfectly acceptable to the opponents of the Kelo decision. And what's not acceptable is that you have this done by free enterprise. The result of the position taken by most of the Kelo critics is to say that it's okay for government to engage in various activities, not okay for the free market to do it. One of the reasons given by Justice Stevens, and given well back into the 19th century by the justices and state court judges who said public use means public purpose, one of the reasons they give for why you don't want to have a restriction that says you can't facilitate a public purpose through a private actor is because that gives states and localities an artificial incentive to have everything in the state-run sector. It's an artificial disincentive to privatization. I would have thought that a good, solid conservative position would be that you want incentives for privatization, not artificial disincentives for it.
1 minute.
The real issue, I think, is the fear of abuse. And I don't want to minimize that. I think that anybody who has to give up their home when they don't want to, even if they're paid just compensation, suffers a very serious detriment. The question is, what are you going to do about that fear of abuse? The standard approach of constitutional law since the late 1930s is to say, let's rely first on the political process. That political process here is working marvelously. The question then is, well, what if it breaks down in a particular case? The Supreme Court said in the Kelo case itself, we are leaving open the possibility of challenging any particular use of eminent domain where it looks like an inside sweetheart deal. And they said there wasn't evidence presented of that in the record in this case. But in many of the examples that are presented as abusive, I have little doubt that if a proper showing could be made of what is alleged in the public debate, then under the Supreme Court's Kelo decision itself, and under decisions cited by the majority and emphasized by Justice Kennedy in his crucial fifth vote concurrence, those abuses could be handled. So the question here is whether you want to deal with these individual abuses by reviving a jurisprudence that says the Supreme Court knows best, when our experience in the first part of the 20th century was that this was a disaster. I think that's a disproportionate solution. The appropriate solution is the one we're seeing in the political process. Thank you.
Let me ask Scott Bullock if he's heard anything he might disagree with.
Only 5 minutes to do so. Let me just briefly run through a couple points the professor made. One concerning democracy. and whether the democratic process is an effective check upon the abuse of eminent domain. And I think the recent experience with what we're seeing in the legislature demonstrates the need to have a meaningful judicial check on the abuse of eminent domain. The Fifth Amendment is an explicit part of the U.S. Constitution. It isn't a penumbra or an emanation or some of the other rights that have led to so much controversy about whether or not the judiciary should be active in protecting constitutional rights. And it is an explicit part of the Fifth Amendment. And all members of the Supreme Court, even the ones in the majority, as Michael pointed out, recognize that the judiciary does have to play a role in policing the use of eminent domain. And the type of situations that you see in New London and in other places are great examples of why you need to have this judicial check. Because the folks that are behind these projects are, of course, all the influential people within a particular community. And even though they might not have the numbers behind them, they have the influence. James Madison warned about the danger of faction within the U.S. And that's one of the reasons why we have a constitution, is to prevent the ability of certain people to gain the levers of government in order to use it for their own ends. And that is clearly what happens in a lot of these cases. That Suzette Kelo and her neighbors tried to fight the good fight. Maybe they would even win if it was put to a referendum, but they don't have the influence and oftentimes the time to devote to try to influence the city council to save their homes, especially when you have on the other side of this issue a group, companies that are promising the sun, moon, and stars to the city in the form of higher tax revenues and higher jobs. And this, I'll just give you one example from what happened in the New London case. In New London, they had the necessary hearings, they jumped through the necessary hoops, and the city council listened to all the folks that were affected by this. And of course, they asked the opinion of Pfizer, that had just moved in next door to the Fort Trumbull neighborhood. And part of the agreement with them moving next door to Fort Trumbull was the redevelopment of the Fort Trumbull neighborhood. And the city asked them, the largest taxpayer within the city, what do you want in this development plan, Pfizer? What would you like to see? And Pfizer said, well, we'd like to see a 5-star luxury hotel, upscale condominiums for our temporary employees, and private office space for our subcontractors. And the city said, thank you very much. Listen to the residents, Suzette Kelo and the others pleading for their homes and to at least retain some of the housing that was in the particular neighborhood because there was so much land available to do development. And they jumped through the hoops and they had the democratic processes. And at the end of the day, guess what the development plan had in it? A 5-star luxury hotel, upscale condominiums, and private office space. Now, Michael was right. There's no evidence that the city did this because they had Pfizer stock or they were friends with the Pfizer corporation's board of directors. No. They did this because their attitude is what's good for Pfizer is good for the city of New London. And that is the problem. Once you say that things like taxes and jobs or public uses or public purposes or public benefits, then it becomes very hard to separate out public and private use, because the only way that the public is going to gain in the form of higher taxes and more jobs is if the private company is successful, if it earns a profit. So of course you want to give as many benefits and provide as many incentives to the private company as possible in order to do so. So it's essential to have a judicial check on this, and the Supreme Court failed to do so in this case. Just compensation, I think in many ways, is not an effective check. Just compensation is not what oftentimes people would gain if a developer had to buy it through private purchases and sitting down and negotiating. And the other problem that you have, for instance, like the city of Norwood, which is the case before the Ohio Supreme Court, and I've seen this over and over again in cities, is that the developer tells the city, you know what, we'll pay for the condemnations. You use the eminent domain authority for us, and to give us the property, we'll pay for the cost of the condemnation, we'll pay for the property, we'll even pay your legal fees. when you have to defend these actions in court. So it's a renting out of government's eminent domain authority, so therefore you don't even have the check of the public purse on the abuse of eminent domain. So that is another reason why it is essential to have these types of effective judicial checks upon the use of eminent domain. I think I'll close with that. Thank you.
Again, thank you. Michael, we'll hear some additional thoughts from Michael Dorf.
So, is what's good for Pfizer good for the USA? Well, when you put the question that way, it does seem like it's a really nasty proposition to have to defend. And yet, I would ask you, think of yourself in the 19th century, and the question is put, is what's good for the Pennsylvania Railroad good for the USA? Is what's good for the Erie Canal good for the USA? Is what's good for the company that's going to build the bridge that needs the land that the people don't want to sell good for the USA? What distinguishes these public works projects from the sorts of public works projects we have today to revitalize our downtowns? Now, I think myself, as a legislator, I could perhaps draw distinctions among those. I don't think, and I don't think that Scott or anybody else has suggested, that anything in the text of the Constitution remotely suggests a difference there in kind, rather than simply in how one sort of feels about the particulars of the case. It's interesting to note that the proposition that use means that the government has to actually use the particular land rather than to give it to a private party got exactly one vote in the Supreme Court, Justice Clarence Thomas. All other 8 justices accepted the long-standing precedent, including, I'll tell you about 2 little cases. One case called Berman against Parker from the 1950s, was a case in which the Washington, D.C., per Congress, was going to have a project of urban renewal, and what they planned to do was to deal with what was called blighted housing stock, because housing stock, most of which was uninhabitable. But it turned out that part of the area that they needed to deal with was a building that was in perfectly good shape, and it was a department store. And the owner of this department store said, you can't take my department store, I don't want to sell it to you. And they said, well, look, we'll pay you just compensation. He says, I don't care, I'm going to go to court, I'm going to challenge this. Court said unanimously, no, this counts as part of as a public use. Why? Because you can have a comprehensive plan even if your particular property isn't blighted. Justice O'Connor, the hero of Scott and others here, says in the Kelo case, that's perfectly acceptable. So she accepts that principle. Only Justice Thomas is willing to say, no, we're going to roll you back to a notion in which the government itself has to use the property. So when Scott says this is based on the Constitution itself, the text, use, is what divides the 8 justices from Justice Thomas. It's not what divides the 5 from the 4. Another case, Hawaii Housing Authority against Midkiff. This is the case that actually should have generated all the outrage if the case is going to generate outrage. This is a case in the early 1980s in which Hawaii looked around and they noticed that nearly all of the land in Hawaii was owned by a very, very small number of landowners. And what they said that this is artificially affecting the price of housing in Hawaii. So what did they do? They said, we're going to take the property from the landlords and give it to the tenants. We're going to pay the landlords just compensation. We're going to give it to the tenants. Why? Because we want to break up these large land holdings. Now, if ever there was a direct transfer from one property owner to another, that would be it. And there, too, the Supreme Court said, that's okay. Why? Because it's in the public interest for the government to deal with this problem in the market. Now, you don't hear about these cases. Why not? Because this is a case where the argument against what the local government has done, and here the state government has done, is not so sympathetic. Here the beneficiaries of the public, of the power of eminent domain are much more sympathetic. It's the little guy. The Supreme Court, however, is neutral as between the cases in which it's the big guy who's benefiting from the use of eminent domain and the case in which it's the little guy. The Supreme Court's view is we are not better situated to decide what counts as a public purpose than are the people's elected representatives. Finally, Scott said that there's a problem with just compensation because you don't get as much as you would get in negotiations. That's, to the extent that that's true, it's a good thing. And the reason is because of a problem that economists know as the holdout problem, right? Which is, suppose that the government wants to build an airport, and you have one of the plots of land on which they want to build it. So they start buying up all the land around you. As they get closer and closer to assembling all the land they need to build the airport, you can charge essentially an extortionate price to get the to sell your land if they have to buy it from you in a free market sale. That's why, in general, just compensation is defined to mean what the fair market value would have been without this additional holdout premium, which is just a sort of giveaway to the person who's doing this. Just compensation is something that is enforced by judges and quite vigorously. Really, finally, Scott says that you need to have a judicial check. I don't necessarily disagree with that. What I'm saying is the Supreme Court in Kelo affirms a reasonable judicial check. If you think you need a stronger judicial check, by all means, authorize it through state or federal legislation, through state or even federal constitutional law. The Constitution we have, as correctly interpreted by the Supreme Court, doesn't provide a more vigorous one. Thank you.
Let me raise a couple of questions for both of our speakers. First of all, really for Scott Bullock, Professor Dorf essentially says the court followed the law. Now, you may not be happy with the outcome, but they followed the law as is written, and you might want to change the law. How do you respond to that?
Well, it's an interesting question because I've gotten this, debated this topic in a number of law schools, and this is something that that has been discussed in several of those forums because there does seem to be a gap between popular perceptions about this case and the view in the legal community and especially in the academy, which is, well, why is this case so controversial? This has been going on for 50 years at least, and we've had these decisions and so forth. And to a certain extent that is true. This is a case which was really a wake-up call. This is an area that we've been litigating for a number of years, but there was not a lot of public awareness about these cases. They usually arose on the local level. Maybe somebody heard about it on the news. I think there was growing awareness about this. A year before the Supreme Court took up the Kelo case, the 60 Minutes did a segment on eminent domain abuse that got a lot of attention and really, I think, raised the profile of this issue. But it had really not reached the national stage in the way that it did when the court first took the Kelo case and then decided it. So there is, to a certain extent, that this is something that has been going on for a number of years, and this has really raised the profile of the issue and shined a public spotlight on it and made people aware of what has been happening. But I think with regard to your specific question as far as the legal issue is concerned, yes, the Supreme Court had these broad decisions over the past 50 years that gave significant deference to the government to use eminent domain and to decide what is a public use or a public purpose. But the Supreme Court had never decided this issue. And state Supreme Courts, in interpreting the Berman case that was mentioned before and the Midkiff case, came to differing conclusions on this particular issue. And the Supreme Court, to give its stamp of approval to this, I think is quite significant. In the Berman case, there was a lot of questions about whether or not the constitutionality of urban renewal was going to be approved by the Supreme Court. In the wake of the Supreme Court's decision, 33 states approved the use of eminent domain for urban renewal purposes. So the Supreme Court giving its blessing to something does oftentimes further what the government is trying to do. But as Justice O'Connor pointed out in her dissent, and I think it's one of the ways we distinguish this case, because the Kelo case was about really a question of limits. The Berman case dealt with a blighted area. Yes, Mr. Berman's property was not blighted, but the area itself was in very bad shape. The Midkiff case involved an oligopoly of land ownership. Oligopolies, blighted conditions, something that could be considered a harmful or offensive condition. The Kelo case, it's important to remember, involved ordinary properties, a typical working class neighborhood. There was no allegation it was a blighted neighborhood, no allegation that was a problem with the property. And so for the court to say, it doesn't matter the condition of your property, it doesn't even matter the condition of your area, if the government can come up with a higher and better use for your property, that's an acceptable justification for the use of eminent domain, is an expansion of eminent domain, and really does put at risk all areas, regardless of their condition, for the use of eminent domain for private development. So I think, yes, it was in keeping with these broader cases, but it was even a further expansion of this and really shined a public spotlight on this issue.
Professor Dorf, would you agree?
Partly. It's true that the prior cases did use those specific reasons, talk about those specific reasons as the reason why the public purpose was satisfied. But as Justice Stevens points out in the majority opinion in the case, there's nothing in those cases or any other case that says that the public use looks to what the land is being used for now as opposed to what it's going to be used for in the future. So for example, imagine a classic use of eminent domain power. The city wants to create a public park, which will be open access to everybody. It's going to be owned by the city. And there are a few people who don't want to sell their property right smack in the middle of where the park is going to be. The fact that their property is not being used for any offensive purpose today does not count as a reason why it can't be taken through the power of eminent domain. And so the burden on Scott, and I applaud him. I mean, I think he did a wonderful job getting 4 votes in this case, because when I went to law school, in my property class, we were taught that this is just slam dunk. Public use means public purpose. Government can take it for anything it wants. So the fact that he got four votes for his, even though he lost, he only lost 5-4, shows what a powerful advocate he is. But the burden on him, and I think this is why he only got 4 rather than 5 votes, because the burden is a little too high. The burden is to show why you would have a different rule, that is to say, one that looks to the input side rather than the output side for where the public use is development rather than any of these other purposes, as to which the text of the Constitution doesn't distinguish.
And let me ask you a question. You emphasize, I think, that any of the taking always involves compensation. And in fact, you indicated that it was to be just compensation, and that one, in fact, had to be careful that people weren't holdouts and seeking even more than they might deserve. But that sort of begs the question of people who just don't want to sell. I want to die in my house. How do you deal with those cases?
Right.
There is no just compensation if I want to die in my house.
No, that's right, and this is why, I mean, the law of property typically says that land is unique. If we make a contract to sell a car, and I'm supposed to sell somebody a 1997 Toyota Camry, and for some reason I'm unable to deliver that car, the law says that I have to just pay the value of the Toyota Camry, and the person on the other side of the contract then goes out in the market and buys a 1997 Toyota Camry, because we assume that he didn't want my Toyota Camry, he just wanted a functional Toyota Camry. The law generally says land is different, and people feel that way about their property. So I understand that question. The judgment of the framers of our Constitution and of the courts over the years is nonetheless, where the people think it's a sufficiently important reason, we can overcome that. That is to say, there is a strong presumption that people ought to be able to say, I don't care what the free market value is, this is my house, I'm staying here, is entitled to great weight, but the weight it's entitled to is enforced through the Just Compensation Clause and through the political process.
And let me ask both of you, if you were framing legislation, if you were heads of city councils or state governments, and you had to approach this as what I've described as a spectrum, from the clear cut, this is the narrowest point of the river, this is the only point we're going to build, we need a bridge, we have to put it here, to it would be nice, we could improve the neighborhood if we put in a Gap or a Banana Republic store. Along that spectrum, where would you draw the line?
Well, we have a couple alternatives that we're offering for legislatures. We do have model legislation that we've crafted to try to address the issues that arose in the Kelo case. And there's two issues that we typically deal with. One is what was at issue in New London, which was the use of eminent domain simply to improve the economy, to generate more taxes, to generate more jobs. And we are encouraging legislatures to simply prohibit those types of takings, that this is a vision of eminent domain really without limitation, that it's not in keeping with historical traditions, it's so subject to abuse that it should just be eliminated and prohibited under state law. The second issue that's very important to deal with, and we've been encouraging legislatures to do so, is what we call the abuse of blight laws. Because arising out of the Berman versus Parker decision, where the Supreme Court approved the use of eminent domain for urban renewal, or so-called slum removal or blight removal, to use the terminology of that time, that many states have broadened their blight laws. Originally, it was designed and typically used in neighborhoods that were in poor shape. Of course, there were horrible abuses of this, as just about everybody recognizes, because even though these neighborhoods were poor, they were true communities, and once people were uprooted, oftentimes they were never able to recover as a result of this, and you saw massive displacement of the poor, oftentimes minorities. But if you're going to have urban renewal laws and you're going to have blight laws, they should be written in a way that addresses true problem properties that are dilapidated, properties that are tax delinquent, properties that have essentially been abandoned, rather than some of the criteria that you have in many state laws, which is such things as economic obsolescence, functional obsolescence. Because what we've seen in community after community is governments will declare certain areas to be blighted simply to get eminent domain authority. Because under the Berman decision, if an area is blighted, the removal of the blight is the public purpose. So therefore, there's an incentive on the part of governments, oftentimes working hand in hand with developers, to declare areas blighted. And if you have this broad and open-ended criteria, then you're really going to have the use of eminent domain for private economic development, more taxes, more jobs, in a backdoor way, because they can essentially declare any neighborhood to be blighted. I'll just give you one example of that. A case that was actually highlighted in the 60 Minutes segment that I mentioned a while ago. The city of Lakewood, Ohio, declared a perfectly fine middle-class neighborhood to be blighted under the criteria of such things that the homes lacked two-car attached garages, there's less than 2 full bathrooms, and they didn't have central air conditioning. That was the blight criteria, which would have blighted the homes of every city council member and the mayor, as Mike Wallace pointed out to the mayor, and about 90% of Lakewood. But Lakewood's law said such things as functional obsolescence. These homes were obsolete. They were built over 50 years ago, so that was a justification. The real justification was to get eminent domain, to give to a developer, to build a lifestyle center, and to get these people out of there. So that's why you have to eliminate eminent domain for private economic development and address the state's blight laws.
On the other hand, in the case of the Nissan plant in Mississippi, where you were clearly a pretty impoverished area, clearly a massive economic development project, and yet you were going to help this family hold on to their house.
Right. Well, that was
Not the greatest good for the greatest number.
well, not under our system. But that was a case too that we've seen over and over again, and we showed it in the Nissan case. This is a case where Mississippi had given a lot of money to Nissan to build a plant there, had given them a lot of land, and they wanted to take the homes of the Archie family, an African American family that had lived there for generations, who didn't want to sell. That was a case where they didn't need the land. It was at the tail end of the project area, and that's true in case after case that we've seen. It's also true in New London. New London has right now in the Fort Trumbull neighborhood over twice the property available to them to do development than what New York has to rebuild the World Trade Center. Over 27 acres right now of property, free and clear, nobody objects, the property owners don't object to it. There was a former military base that the government gave to the city of New London, and the property owners say, go ahead and do it. We just want to hold on to our homes, which, by the way, constitute 1.54 acres of property. So in these cases, over and over again, adjustments can be made, development can be done, and people can still hold on to their homes and small
Professor
businesses.
Dorf, where would you draw the line if it were up to you?
Well, I think it's important to understand that where I draw the constitutional line is different from where I would draw the line were I a politician. Justice Oliver Wendell Holmes Jr. said famously in his dissent in the Lochner case, that's the Baker case I talked about a little while ago, that the Constitution does not enact Herbert Spencer's social statics. Now, nobody today remembers who Herbert Spencer was, except for this quotation. Spencer was an economic libertarian, and Holmes himself, in his personal political views, was an economic libertarian. He thought that socialism and even much of the welfare state was foolish, but he understood the difference between his views as an individual citizen and his views as a justice sworn to uphold the Constitution. So I think if I were asked, well, what do I think as a citizen? I don't think my views are that different from what Scott's are. I think that I would make 2 points. One is, you'll notice that to get the rules you want to actually deal with all the sorts of different problems that arise, the different sorts of abuses, actually is going to take a fairly detailed code. And the question is it more appropriate that the justices of the Supreme Court write that code pretending to be interpreting the word use, or that the people who are better able to write codes, namely legislators, write it? So I think that's a question of allocation of institutional authority. But if we're asking what the legislator ought to do, I don't disagree with much of what Scott says. I would emphasize 2 additional factors. One is sunshine laws, that I think it's very important that there be an open process for these sorts of decisions, because, as Louis Brandeis once said, and others people have said, sunshine is the best disinfectant. If the problem is backroom deals, then this is the way to bring it out in the open. And the other is competitive bidding. That is to say, in a lot of these cases, the real problem is some sort of sweetheart deal for an insider. You can deal with that with competitive bidding. And I should point out that both of these approaches, sunshine laws and competitive bidding, address the broader problem of government abuse, for example, in contracting, or again, in appraisals, not just the problems with eminent domain.
Well, I think it's interesting that in many cases the Supreme Court has the last word on an issue. When the court comes to issues its opinion, the issue in effect is settled. In the Kelo case, I think it has not settled issues so much as raised a number of important issues. We will see the process go forward in a number of states as the citizenry seeks to come to grips with the issue of eminent domain. Just what does it mean? I think for many people it means different things now than it did in the 19th century when we were talking about things like the Erie Canal and the building of the railroads. There's an element of NIMBY in this. I don't want my home taken over for a Ritz-Carlton hotel. I'm not sure if I want anybody else's home taken over for a Ritz-Carlton hotel. But it's an interesting issue and one I think we'll be hearing much about going forward. So at this point, our time has elapsed, and I would ask you to simply join me in thanking our speakers.